My name is Sope Williams-Eligbe, and I'm a professor of public procurement law at Stellenbosch University. So I'll just say a few things, and I'll come at it from the public procurement angle. So the first thing, so non-trial resolutions, they have their place, and they're good in the sense that they help to avoid the collateral damage that can sometimes happen to companies, when they go through the criminal justice system, and they also, conserve judicial resources. If you like, if you look at what happened with Arthur Anderson, for those of you that can remember that time, so they have their place. But there's some other, I should say, sticking points that many systems don't give adequate attention to. So the first is that non-trial resolutions have an impact on the debarment system in public procurement. Many countries rely on a conviction for companies that have committed illegal or unethical practices to be debarred. Now, if you enter into a non-trial resolution and that conviction is removed, so to speak, then you still remain liable in many countries to have access. You still remain able to have access to government contracts because you're not going to be debarred, and that is from the public point of view, the optics of that don't look good, right? So that's something that we have to think about. And beyond the optics, it's like, okay, is this something that we really want to happen? In some countries, you have, especially very big companies who have entered into non-trial resolutions, recommit offenses. So there's some degree of corporate recidivism. And in later offenses, their earlier conduct isn't taken into account in terms of sanctioning and disciplining them. So that's something that also needs to be considered. Then many times you find that big companies can enter into non-trial resolutions because they have the sophisticated law firms behind them, where smaller firms don't. And that also creates an optical problem of, are these firms able to quote and unquote buy their way out of justice, which is why the point that Jennifer mentioned about making sure that governments still pursue or criminal justice still pursues custodial sentences against culpable individuals is really, really important. The other thing that I like to talk about from the South African perspective, what we've had in the past, is that in terms of corporate disclosure, companies haven't been very sincere, if I can say that. So if I give the example of Bain, for instance, when they came out with their own investigation on what happened, it was laughable. And it created a whole new set of problems. So corporate disclosure hasn't had a good track record in South Africa. And there have been a few other companies that were implicated in state capture that were also, not as sincere as one would have hoped that they would be. So we need to think about this. And I think the other thing that is important for me is, like, if we institute this in South Africa, what do we really mean in terms of restitution? So the events that we've had in the recent past, we've had these companies returning the fees that they were paid when they engaged in their state capturing activities, but that doesn't really meet the damage that was caused to South Africa, to society, to the enterprise, to the organs of state that they were engaged with. So what do we really mean by this type of disgorgement? How far does it go, especially seeing that the damage that has been inflicted in South Africa, especially in the recent past, is very different from what has happened in countries like, the UK or the US, and the kinds of damage that they, that they had on in terms of their own corporate bribery and corruption. So I think those are the things that are of concern to me. And I think these are issues that obviously the Minister of Justice and his team would have to think about as they implement these recommendations. But I wanted to say that when we talk about whistleblowing, I always like to take a step back and talk about what is the culture in the firm or in the public sector in terms of speak up and challenge. Because before a whistleblower goes public, they must have tried to resolve this issue internally. And in the work that I've done, there are two things that determine whether or not an organization will end up with an ethical scandal. It is the leadership, whether there's ethical leadership, and whether there's a culture of challenge and speak up in the organization. If these two things are present, then ethical failures are usually addressed before they can blow up into something else. And I think that's something that we don't talk about in the public sector in South Africa. We know that some political parties use positions as a reward. even when people have been implicated in serious ethical issues, they are rewarded with positions in other organizations, and so we don't really focus on the character of the people that we have in the public sector in positions of leadership. It's one of the recommendations of Zondo, but I think it's a conversation that South Africa really needs to have, that the character of the people that we have, are we happy with that? And if we're not, what is the way forward in making sure that we don't, recycle people who are or have had a dodgy past than demand side in terms of enforcement. And that's for a number of reasons. It's because obviously we know that corruption cases are difficult. We've talked about that. Sometimes there isn't enough evidence in the host country, if you like, statutes of limitations, and sometimes immunities that public officials might have while they are in office, or political office holders might have while they're in office. So these are some of the challenges that demand side bribery has, or enforcing consequences against public officials, if I can say that. So we have a problem. And when we talk about enforcement, a lot of the foreign bribery enforcement relates to two types of transactions: public procurement as well as tax administration. And so that's where we see a lot of foreign bribery happening, a lot of the demand side bribery happening. So South Africa, we know we've criminalized foreign bribery. And we know, especially from Zondo now, we know that a lot of the procurement corruption is conducted, or at least the state capture is conducted by local firms as well as foreign firms. I don't think there's really a lot of difference in prevalence. The foreign firms who were able to, get their hands dirty seem to be very willing to do that. And I think we haven't really seen enforcement of foreign bribery because we haven't seen enforcement of domestic bribery. So our bribery, we don't really make a distinction. We don't look at Bain, for instance, or KPMG and say these are foreign companies. Like, these are companies that were bribery, that were abusing the procurement system, as well as the domestic companies as well. So what we have to do is to really enforce. I would just say really enforce. Procurement corruption, whether it's done by foreign companies, whether it's done by local companies, the effects are the same. At least the effects on South Africa and South Africans are the same. And both domestic and foreign companies are gaming our system, and we need to address that. What many countries do, especially developing countries, in trying to deal with this, deal with demand side bribery, is to use the anti-money laundering framework, because sometimes it's easier to do that, to actually target people using those laws than using corruption laws, because of the burden of proof, the secrecy involved, etc., etc. Some of the things that I've talked about. One of the recommendations that the OECD proposes now is that we need to have greater international cooperation and better reporting channels. I mentioned the fact that we don't have a symmetry between supply side bribery and demand side bribery. But it still seems that these reporting channels, the existing channels, aren't working. So there does need to be sort of an international conversation on, what kind of reporting channels should countries be using. Many of the foreign bribery enforcement comes by way of media reports, and not really by conversations between countries, criminal justice, or prosecutors or investigators. So we need to countries need to think about, what do we want to do? How do we want to work together to actually get this information out there? And then the other thing that I think I've mentioned already is really the ethical standards and the character of people that we put in procurement, but across the civil service, political leadership. One of the Zondo Commission recommendations is to have a look at the professionalization of procurement. We've talked about that, but also the ethical standards of procurement officials, because I think that is one of the missing pieces, especially here in South Africa, and that's one of the things that we have to really consider. In terms of there's actually, for me, and I think someone else has already mentioned this, there's a lot of synergy between, I think the minister mentioned this actually, there's a lot of synergy between the Zondo Commission recommendations as well as the new OECD recommendations. So if the South African government can actually implement some of these, they will be, killing two birds with one stone. The final point that I want to make is in terms of including the private sector in policy formulation, that's one of the OECD recommendations. That's also a Zondo Commission recommendation. And Stellenbosch University is actually trying to drive the conversation on that through our new academy known as the Pavagat Stellenbosch Academy. So you can look out for information on that. So I just wanted to plug that.